want to do is this, for those of you that are watching, please mute yourself. And what's going to happen is we're going to do interactive. Now realize, for those of you that don't know, I have not gone through any of these essays. Yes, I do have an idea of what was tested because, you know, I do talk to my students and I read things and whatnot, but I have not actually seen the fact pattern. So this is how we're going to do it. I'm going to go through the fact pattern exactly how I teach my students to go through it, exactly how I would go through it on the bar, exactly how I've always been doing things. And so if I miss something or if I, just let me go through it. I have not gone through it yet. A lot of times people start jumping all over me, like when I'm like, I'm on the first paragraph, like, give me a second. So, and then afterwards we'll open up for discussion. I'll let you guys see, I'll tell you what I think of the essay. So essay 1, from what I understand, was one of the ones that most people were happy to see. Although they hadn't tested murder since 2008, which is a long time, and it's still the most heavily tested topic in murder in the history of the California bar exam. I think most people were happy to see it. Okay, so please mute yourself. If you have a question, you're gonna raise your hand with the reactions button. And then like that, boom. That's all you gotta do. All right, so if you could just mute yourself in there and let's go. I'm ready to start the essay. We all good? Let me see, I gotta take my reactions down. Lower hand and get rid of that. All right, all right, Ethan, get rid of my reaction. How did I get rid of that? All right, here we go. All right, question 1. Let's go. Ethan, are you doing it? Oh, thank you. Okay, so this is how we do it. Always go to the call to question first so you know what you're thinking about. Number 1, with what crimes? So I already know right off the bat, just with what crimes, it's going to be criminal law. It's the examiner's way of telling me that. Could Jim reasonably be charged with? And there's a difference between being charged with a crime and being convicted. It's a subtle difference, but I mean, you can be charged with pretty much everything. You can be charged with robbery and larceny. You just can't be convicted of both. So they're asking you, what can you be charged with? That's the examiner's way of saying it's a little bit broader than what can he be convicted of or what is he guilty of? What can he be reasonably charged regarding the events at the store? So Jim at the store, I'm surprised they call him Jim because usually it's defendant or a co-conspirator. It starts with a D or a C. Or you'll have Abel, Baker, Charlie to make it easy. Hey, Vicky. Okay, so number 2, with what crimes could Jim reasonably be charged regarding the incident on Park Street? Okay, so we have the store, and then we have Park Street. So 2 different locations. I'm going to venture, just because of the way they write the exam, is I'm assuming that they're probably going to be in different paragraphs. For those of you that don't know it, on a lot of essays, I would say about 60 to 70% of them, it's very dissected. Like paragraph 1 will go to essay 1. Paragraph 2, paragraph 1 will go to call number 1. Paragraph 2 will go to call number 2. And if you look at a lot of essays, you'll notice that they're really kind of, it's like 3 little small hypos. Call number 3, under the 4th Amendment to the United States Constitution, so there's the crim pro aspect of it. So I can tell right now it's a crossover. Can Jim successfully move to suppress the gun from being introduced into evidence at trial? So he wants to file a suppression motion for the gun. All right, so that means, was his 4th Amendment rights violated? Did the police have a warrant? Probably not. They almost never have a warrant. If they do, it's going to be faulty, or else we wouldn't be here. So you're going to come down to whether or not the police action was reasonable, and that's going to fall into an exception of the 4th Amendment, and whether or not okay, we got that. All right, let's take it from the top. Jim and Fred armed themselves right there, conspiracy. I mean, how do you have 2 people going into the store at the same time at the same place? So right there, I don't need a checklist. I don't need a template. I don't need any of that nonsense that people try to throw at you. I see 2 guys walking, armed themselves with handguns and drove to a store on Avon Street. Okay, right there. What the hell? Fred's not in the call to question, so that's interesting. Let me guess, he dies. So Jim and Fred armed themselves. So right there, we have a conspiracy to commit burglary or robbery, probably both. In fact, they could be charged with both because it's commercial burglary, robbery, and drove to a store on Avon Street. So they're probably going to rob the store. They both went into the store, drew their guns. There you go. Now, if anyone dies, it's going to be felony murder because it's during the commission or the attempted commission of inherently dangerous felony. Drew their guns and demanded that Salma, an employee, I actually did go into Selma. Give them the store's money. Okay, so they're robbing the store, committing burglary. Well, not a common law burglary, but modern burglary. All right, so right there, we already know what's going on. I mean, it's just really simple to kind of put this stuff together. I'm sure this wasn't a very difficult question for a lot of people. After Selma handed Jim the money, he nervously dropped his gun. Okay, the gun discharged when it hit the floor, and the bullet hit and killed Chris, a store customer. Oh, that is felony murder. Wow. Okay, because here's why we have felony murder. Felony murder is for accidental killings. If you intentionally kill them, they don't have to prove the underlying felony. They just have to prove that you intentionally killed them. So felony murder will go to, a majority of the time, an accidental killing that happens during the commission or attempted commission of an inherently dangerous felony. So we got that. Yeah, he actually killed him directly. Wow. That's interesting. Jim killed him directly. Wow. All right. Gun discharged and killed Chris, the store customer. Why do they call him Chris? That makes no sense. They should call him victim, Vic. I mean, these are weird names. Selma then got a shotgun from under the counter and shot Fred up. Now that's not felony. Okay, so here's the thing that most people don't realize. The examiners will never test the exact same issue twice. I know a few of you are like, oh, they did negligence 3. No, they didn't. No, they didn't. They were testing proximate cause in one. They were testing breach on the other, and whatever, damages. Okay, so one, we have the accidental killing for felony murder. Now, when Selma killed Chris, that is not felony murder on the majority agency theory, because under the agency theory, it has to be you or one of your co-conspirators, your agents, who commit the crime. Because this was not one of their co-conspirators, it was resistance by the victim, then there is no felony murder. So there's 2 situations where you discuss felony murder, one where it is and one where it's not. Very standard stuff the examiners do. Okay. Hit and killed Chris, store customer. Selma then got a shotgun. Okay, we got that. Jim picked up his gun and ran out of the store and drove back to his apartment. Notice that entire paragraph goes to call number 1. And Lauren, I'll get to you and listen. Go ahead, Lauren. If you have a question right now, I'll go ahead and take that. Just because I might be doing, go ahead.
Yeah. On this exam, I very much remember the first essay, and I don't remember it being like this. I suspect it's different because on the essay that I answered, Jim dropped his gun and accidentally killed Fred, and Selma, the store clerk, shot at Jim as he was leaving and killed Chris. So this is different.
You know why?
Why?
Because you read it too fast.
I don't know about that. It was also the first question. So it's like, I'm trying to remember. I don't remember a lot of the essays, but I do remember the analysis, and I was going through piece by piece.
Interesting. Well, I think your mind just plays tricks on you.
Also, one little fact in the second paragraph is also missing. It said Jim saw Selma.
Oh, hold on, I'm not there yet. Lauren, okay, Lauren.
Wait. No, I'm just telling. What I'm telling you is that this seems different because Selma did not notice Jim
Lauren,
shot at her.
Lauren, it's not different. Not in here. Lauren, please. Ethan, okay. Please mute her. Thank you. Okay. I'm going to the second paragraph. Later that, and Ethan, if you okay, later that evening, Jim saw Selma while walking down Park Street. So this is going to go to call number 2. I can already tell. Thinking that it could eliminate her as a witness, which is a good idea. Jim shot at Selma with his gun, but the bullet missed her. So that's attempted murder. He's had specific intent to kill. Don't forget, murder has an act and it has intent. The act is the killing of the human being. The intent can be found in one of 4 ways. That's malice aforethought: intent to kill, great bodily injury, felony murder, and depraved heart. But here, he's clearly have the intent to kill, specific intent to kill. That's why you can only get all attempts are specific intent crimes. Okay. Thinking that he could eliminate her, okay, he shot it, but the bullet missed her. Then Jim drove away. All that is attempted murder. Do I see anything else there? I mean, that's all I see. He shot at Selma. The bullet missed her. Jim then drove away in his car. That's attempted murder. That's it. I mean, that's really not a lot there in call number 2. I'm just going to read it one more time to make sure I didn't miss anything. Later that evening, and I always, just so you know, for those of you that don't know me, I will read the fact pattern. When I take an actual bar exam, and I've taken the bar exam in multiple states, as many of you know, I will read the fact pattern 3 or 4 times before I even start writing. If you are sitting at the bar exam and you hear somebody banging on the keyboards in the first 30 seconds to a minute, please give them my information. They're going to need it. Okay. Yeah, that's it. Attempted murder. That's all. All right. And let me guess. Paragraph 3 goes to call 3. Man, they do the same. For those of you that don't realize it, the examiners do the same stuff over and over. It is literally, I've been on Groundhog Day repeat for about the last 9 years doing this, because after you go through 6 or 7 essays carefully and correctly in one subject, you're going to see the same stuff over and over again. There is no tricks on the bar exam. It's actually a lot easier than people make it out to. And I am disgusted that they lowered the score. I know it's not going to be a popular view. I wish it was 1490, not 1390. Don't kill me now. Okay, a few minutes later, police officer Baraki saw Jim driving down the street. He had no knowledge of the events at the store or Park Street. The reason why they're telling you that is because they had no probable cause and no reasonable suspicion. That is exactly why the examiners are saying that. So if he stops them, we're going to have an unconstitutional stop. And I don't know anything about what happens here, but let me guess. He stops him for no reason. Just a guess. Pull Jim over because, yeah, there you go. Look nervous. Okay, no probable cause and no reasonable suspicion. All right, and this is an unconstitutional stop. And interestingly enough, they should have, you know what, if they really wanted to get a little fancy with you, this is what the MBs will do. If he had a passenger in the car, and let's say the passenger was the one who committed the crime, the passenger can challenge the stop, the unconstitutional stop, but the passenger cannot challenge a search of the car because they lack standing. Interesting how that works. I would have loved to see them do that, kind of throw you guys for a little twist. The MBEs I have seen, I think they even released one where they did that, but they definitely tested one when I was taking one of the exams. When Jim got out of the car, Officer B noticed a bulge under his shirt. Well, that's not enough to get. I'm thinking right now, is that enough to give you? It's not probable cause. Definitely not probable cause. No, that's not even reasonable suspicion. There's nothing there. There's nothing there. He patted Jim down and found Jim's gun. Okay. That might be constitutional. Now, the unconstitutional stop is going to be fruit of the poisonous tree. So the gun's not probably coming in. He patted Jim down and found Jim's gun. So here's the thing. Whenever they pull you over on a traffic stop, this traffic stop is unconstitutional, so let's put aside that issue. Whenever the police stop you, they can order you out of the car for any reason. They can pat you down for weapons, only weapons, if they have reason to believe that you might be armed or dangerous. And usually that involves being a racial minority, according to most police, or if they have any reason. They're going to pat you down. Bottom line, they're going to pat you down. There's a million reasons. Anytime I confront somebody in any situation, you're a cop, and this guy looks nervous, he's got a bulge, every reason to pat him down. That's totally legitimate. Officer arrested Jim for possession of a concealed firearm and seized the gun. Huh. That's it. Officer Baraki Jim for possession and seized the gun. Well, it's not coming in, even though I would not only discuss the unconstitutional stop, but I would discuss the pat down, because they want you, one of the things the direction says is don't write yourself out of an issue. Just because there was an unconstitutional stop doesn't mean you don't talk about the second part, because you don't know how a judge is going to rule. So, so we're done. Number one, with what crimes could Jim Ruslan be charged? Robbery, burglary, conspiracy, felony murder. And I think that's it. Unless I missed something. I'd have to go back and read it. I'll open up the discussion though. Number 2 is just, I only see attempted murder. Number 3 is unconstitutional stop. Wow. Boy, that was easy, wasn't it? Jesus. I mean, I almost didn't even, I know most of you didn't blink on that. That was the consensus. All right, let's open it up for discussion. All right, so, okay. Anybody have something that, let's talk about it. First of all, really easy question, very standard question. And for those of you that were in my class, We actually did this one, or did a very similar one. They're all similar. The first week of class. All right. So who's got something to say? Lauren, do you want to finish that thought now? I'm sorry that I had to mute you, but sometimes, and please understand, people, I've got to balance the person's individual feelings against like the group that maybe, you know, they don't want people to go on. So does anyone else, let me ask you this, and feel free to like unmute yourself if you want to speak. Just raise your hand so we don't have people talking over each other. Do the best you can with it. Who here thought the fact pattern was different? I mean, Lauren was saying it was different. I just think it's just her memory. But endurance, what do you think?
It's the same.
Hello.
Exactly.
Yeah.
I remember.
Hello.
Well, we'll go to endurance.
Endurance.
I'll call out. So endurance, go ahead.
Yeah, I would like to add to the first call. I think we have, apart from felony murder, I think we also have depraved. The depraved. Yeah, because if you noticed, is the circumstances. I think brought out a gun. Anything could have happened for you to have a gun in that kind of setting. Now I also think we should have like assault, because they said it drew the gun at him. He said he drew the gun at the customer. I think aggravated assault should come in too for the first call. Apart from that, I think everything goes. The robbery, conspiracy, I'm okay with it. Then for the second call, I think attempted murder, I went with that too. Then for the third call, I think it's pretty straightforward. For me, I think the question is pretty straightforward. Yeah.
And you're right about depraved heart. There actually was an essay in 2007 or 2008. I think it was 2007, where the similar situation, they came in there. And I believe both selected answers did discuss about how they came, you know, like it's depraved heart murder. Yeah, you could technically get them for that. Usually when they use like a human shield, you can get them for that. But yeah, okay. And that would be a very ancillary issue. And I'd be curious to see how the selected answers deal with that when they get released in beginning of June. Okay, Lauren, go ahead. Let's hear what you have to say.
Well, I mean, like I said, I do remember the first paragraph being different, but I'm not going to discuss that. On the second paragraph, it's attempted murder, but isn't it also assault or aggravated assault?
I mean, that would be a lesser included offense. Of course, you could probably, I mean, the bullet. I guess so. I just have a weird feeling they weren't. I mean, you're not wrong. I'll tell you that much. And if you were a prosecutor, go ahead and charge it. I just, for some reason, don't think the examiners are looking for it. And I could be wrong.
I totally blanked on it anyway. So it's like it's something I remembered later. It's like I think I could have argued, you know, for an aggravated assault, and the facts didn't say she noticed. So it's like that's two kinds of assault. So whatever. I didn't discuss that at all. I only went through attempted murder. So that's reassuring that that's all you did.
Let me see something here. I'm going to look and see if aggravated assault has ever been tested. Nope. In fact, whoops, close for essays. Yep, assault has actually never been tested on the essays, which is why. And by the way, yes, I did do a search of that. I didn't just like pull that out of thin air. I literally have a list of everything that's been tested and when it was tested. So yeah, I don't ever have assault being tested. Okay, so let's go to Adrianic, and I'm gonna totally butcher people's names just so you know. And Ethan, if you could, after they speak, would you mind putting their hands down?
If I can remember how.
What's that?
I said if I can remember how. I'm trying to get back to my mute and everything else. I'm still learning how to use the Zoom.
Yeah, most people we still have that. All right, Adrianic, just like the New York Mountains. I'm going to call you Adrianic, and so that's how it works.
That's fine by me. My question is in the call to the question, especially for criminal law, it doesn't specify whether it's common law or modern. What should be, which way should we go when it's not necessarily stated?
You know, essays won't actually do that. They rarely give, the MBEs will. MBEs will tell you, common law will tell you, will give you a statute, or they'll tell you it's a bilateral or whatever jurisdiction. Essays are just open book. I mean, what, not open book. They're more open to discussion. Notice, I want everyone to, for those of you that aren't one of my students that maybe not know this, I want everyone to tell me, if you could say in unison, what's the last word on every single California bar exam essay? Adriana, what's the last word on every single California bar exam essay?
Discuss.
Discuss. There you go. Discuss it. So discuss maybe what it was in common law, he wouldn't be guilty of burglary. Modernly, they've included it to include all structures. So that's the examiner's way of by not saying it, they're saying, tell us what you know. Discuss it. Because just like when I went through the fact pattern, I was literally discussing it with you guys. Because that's exactly the way that I would write it on the exam. It's just a discussion. I'm not worried about perfect rule statements. I'm not worried about memorizing anything. I'm just worried. My only job, and this is for those of you, again, I'm more speaking to the people that weren't in my class. There's only one thing a grader looks for. It's not headings. It's not buzzwords. It's none of that bullshit that you've heard, like, oh, just throw everything in there. That's not it either. Apply the law to the facts correctly. Did you apply the law to the facts correctly? Yes or no? That's it. So, did you recognize that this is felony murder of his co-conspirator? Actually, you know what? Back up. I think I actually missed something. Anybody know what I missed? I think I'm just realizing it right now. Someone raise their hand. Go ahead, Lauren.
Yeah, felony murder of the co-conspirator. It's who does the killing of the co-conspirator
Well,
is one of the issues.
I think if I'm not mistaken, it's the red line rule where you can't be convicted of felony murder when one of your co-conspirators die.
Right.
Damn.
It's because it was on the first year law students exam, the one that Kardashian said that she passed, and so her answer was chosen. So everybody's talking about the red line rule now because that was there. The exact same. That first year law students exam is the first part of question one. Is question one? I mean, all of question one is first. Is that exam? Same thing. Matchup. Total matchup. Absolutely freaky.
By the way, just so you guys know, I know a lot of people are gullible, or they read, they read things online or they listen to the news. It's all bullshit, people. Here's the thing. She would never know if her answer got chosen. The state bar does not release that information. Think about this.
They do on the first year law students exam.
They do?
Huh?
They do.
Yes, I have all my answers. I took that exam twice, and I do have those answers, and I have the results. They release the answers.
Learn. Slow down. Ethan, you got to give me control, buddy. I got to be able to navigate things. Okay, Lauren, have you ever, as anyone, I'll prove it, ever seen? Think about this really quick. How many people each year pass the California bar exam? Something like 8 to 12,000, or whatever, something like that. How many people get published? 500 people get published in 20 years. That means, you have like a 1 in 8,000 chance to get your essay published. Now, I've been in law school since 2001, doing this for about 20 years, looking at things. Don't you think when people pass, they post the video, you post what you eat on freaking social media. You guys are so freaking crazy. But if you pass the bar exam, you want to share that with everyone. I totally get that. It's an incredible accomplishment. If you get published, that is an even bigger accomplishment. How come I have never seen a document by the state bar that said your answer was selected as one of the published answers? Has anyone ever seen that? Honestly, have you ever seen that? And if you say yes, show it to me. Don't give me that blank. I had one girl in the class, my last bar. She's like, oh yeah, my friend got chosen after failing 4 times. Like, no, she didn't. And turns out she didn't. She lied to her. Remember that? Who was there in the live class that saw that? That was fun. Oh, Vita, you were there live, weren't you?
This story never dies down, man.
Oh, it's a great one. That was usually one of my favorite days. Marjorie, what do you got, girl? And turn your camera on. And unmute yourself, sweetie.
I was saying I was there that day. She was crying.
She wasn't crying. You guys weren't making it any easy on her.
Jason, her tutor, who was an attorney, was the one, he co-signed it though. He posted that it was her paper that got.
You're talking about Zickman, aren't you?
Published. Sorry?
Wait, who? Kim Kardashian's publisher or whatever did that?
Her tutor, or her tutor that's an attorney, was the one that reposted it. And I remember thinking, how would they know if that was her? Where's the notice from the bar? But Yeah.
Not there. So Lauren, okay, I'm gonna have Lauren, and Lauren, try to stay on track here. Tell me if
I
you
was
actually,
on track. Wait, you got off track. It doesn't matter to me if it was Kim Kardashian's answer or not. But because it was posted that everybody looked at that first question, and it was that first question matched this previous first question for the bar exam. So I wasn't discussing whether Kim was telling the truth or not. I was talking about the red line rule, the discussion of the red
Yeah.
line rule.
yeah, good,
Yeah, I didn't mean for this to get derailed into the whole Kim Kardashian thing or what her tutor is saying or whether it's right or not. I don't care. I was talking about the red line rule.
I just like to correct inconsistencies and things. That's just my nature, just being a teacher.
But don't put it on me that I was saying that was true. That's just the way the news was presented.
Yeah, well, okay, but just so you guys know, it's not true. Unless I see official proof from the state bar, it's not true.
Right.
And I'll be honest
That's
with
how
you.
I feel.
It's promoting bar. Who's KK? Rose. Rona.
Kim Kardashian. Who you're referring to? Yeah. Yeah.
Okay. Well, I'm sure some, it's all about money, people. Just so you know, the answer to every question in life is money. If you just wrote money, on your essay, if you just wrote the word money with a dollar sign, you'll get published right there. It's just like, yeah, dude, he's got it. Like, you know what I mean? Shit, why do you think I'm here? Because my dad's not rich. I mean, if he was, lucky y'all, I'm gone. All right. So let's talk about this essay. Any more thought? I mean, I'm open, I'm here for you guys. I'll be more than happy. And one of the things I was going to do, especially for the people that have never heard me get on my little soapbox and talk, I will tell you about what the examiners do and really clear up a lot of misconceptions. But I'll tell you this much. I will show you a picture of me with Sasquatch and a unicorn. I got them both in the same photo. If you can show me a letter from the state bar that says your answer was selected, it just isn't real. All right, Mina, what do you got?
This is honestly like for the people that are like taking the class for the first time, just looking at the essay and like following everything that you you went over with us and told us, taking this essay, starting with the call, the questions, and like following your advice, man, like it makes you like once you're done with the essay and moving on to the next, that like in your head, like I followed everything Jason did. I analyzed this essay from like top to bottom, pretty much like I left it all out there. Like it gives you that confidence. So like, I guess like what I'm trying to say to the people that are signing up for July and just put it all out there. It's the preparation that gets you there. Like and you even said it to us. And like, when we were like about to take the exam, like the hard, pretty much you've already put in the work into the preparation. That way, when you got to the test day, you pretty much like, this is nothing you haven't seen. So like the first thing seeing this essay, I was like, dude, like we've already prepared for this. And like, it gives you the confidence jumping into essay 2, 3, 4, and 5. Like even when they throw the curveballs, like you've kind of like have prepared for it. So this, I guess.
They don't generally, I mean, so here's the thing too, also, you're going to get, I mean, on average, 2 pretty easy essays, 2 middle of the road essays, and 2 essays a little difficult. And they calibrate things really weird. I have a feeling, I don't know why, my gut instinct, did you guys have, what else did you have? You had the real property. I guess that was an easy
There was
one.
like 9 subjects total. Everything.
Yeah.
Torts, real property. I can't. There's
Community
9
property.
like this.
Community properties are usually calibrated high. Then you have the evidence. I'm sure question number 4 and 5 will be the lowest. Just because people seem to have difficulty with it. Go ahead, Jake.
Oh, evidence, contracts, business law, professional responsibility. There's one that has 3 of them in one. It was pretty wild.
Yeah, well, I mean, with now 5 essays, I think they should kind of go back to the old way they did things. I think you guys should get 7 or 9 essays, probably 7, and having probably 8 and write 6. I think that's a better way to go about it. They used to do that. I don't know if you know this, but in the 70s, they had question. I have question 15 from 1974. Question 15, July. What about that, huh? Yeah, anybody knew about that. Okay. Well, yeah. So, and interestingly enough, when I go through these essays, as I'm writing, as I'm thinking, as I'm rereading the fact patterns, little things will come up. like I will realize, oh, it's not felony murder when a co-conspirator is killed under the red line rule. Anyways, let's see who else has got something to add. I mean, because I'm really here for you guys, so take advantage of it. Yeah. We're gonna pull the ripcord, or what's going on? Anyone have anything to say? Like, let's open up for discussion. Anything you want? Or like,
Yeah.
go ahead, Eric.
I've got as someone who is just starting to crack into the outlines and the sample essays for the very first time, which is, I kind of tuned in mostly to hear you go through your process of how you approach these. I had a couple pretty basic questions about that, if that's cool.
Please, yeah, please.
One is, you know, so I came away from that walkthrough with a very solid outline. If I'm sitting down to draft the essay, I started looking at the model answers. They looked pretty extensive, and I was trying to gather kind of the range between, you know, this is, again, it's very basic, but how much one really needs to write if you're identifying the correct issues
So
between that and the model.
there is no length required. Absolutely not. And for those of you that don't believe me, I can show you a published answer, 2001 July question 6. It was one page, and it was brilliant. It was brilliant in its brevity. So it's not how much you write. Now, the model answers that I have written are not done under time conditions, and in no way should represent what you will be able to write or I will be able to write during exam conditions. But it's a learning tool. That's the whole point of why it's a model. I think getting things correct is more, it's way more important so than being verbose or anything like that. I mean, anytime that you can apply the law to the facts correctly, I mean, there's just, there is a middle ground. And I started writing what's called a short answer, Eric. And for those of you, like, I write a model answer in one page. And I can write a model answer in one page in this easily. I don't recommend doing that, but I mean, it's called, the reason why it's the short answer is because it's like, if you're running out of time, just get to the heart of it. Here it's robbery because the conspiracy to commit robbery. The prosecution can prove that with circumstantial evidence because they both walked into the store with handguns drawn at the same time. So they'll be found guilty of robbery. They'll be charged with robbery. Burglary, even though a common law, burglary is only limited to dwellings, and this is a store, they could be convicted modernly of commercial burglary because they broke in to this, they broke in with the intent, whatever. Then I would go to felony murder, how, murder is the killing of a human being. And one of the intent here would be felony murder. And he wouldn't be found, he shouldn't be charged. He can be charged with the murder of Fred or Chris. Let's see. But generally most jurisdictions hold that, you see what I mean? Like, that's how you'd write a really quick answer if you needed to, it doesn't have to be all flowery, I hope that answers your question, Eric. I think I kind of just went off on a little tangent.
No, it does. I have two more, if that's all right.
Sure, go ahead, please.
I'm gathering from the answers I'm looking at and just kind of walking through this, citations aren't necessary.
No, not at all.
Okay.
No.
Cool.
I mean, yeah, you don't have to cite, no, nothing at all.
Yeah, and this would not be applicable in this question, but I was going through the professional responsibility outline, and I was just thinking about, coming at this as an out-of-state lawyer, will be when it's necessary to describe distinctions between model rules and California specific law, and how we, will that be obvious? Is that obvious from the call? Is that stated explicitly, or is it?
The call, the question is, you'll see when you start going through the essays, we'll say answer according to California and ABA authorities. And
Okay.
there you go, both. So, and as you know, at the end of the PR outline, I'm sure you've gone to it. You may have not gone to it. It's a distinction chart. But bottom line, I mean, what I tell most people, and you've probably already read this, the difference between the ABA and California when it comes to PR, there's literally two things that cover 80% of it. And I always say, carry a pen and keep your mouth shut in California, because California has the strictest confidentiality rules. And you can never get in trouble in California for keeping your mouth shut. So keep your mouth shut and carry a pen. California prefers to put everything in writing, where the ABA is kind of like, well, sometimes it's nice, sometimes you don't have to worry about it. So, you keep your mouth shut and you carry a pen, you'll be fine in California. So right there, if you don't remember anything else, remember that. And there's the distinction. Okay.
Thanks.
Did anybody get anything on this essay or address any issues that I did not address or that you, like, quote unquote, threw in? Which is not a good idea. Go ahead, Lauren.
One of the questions on that first, on the first prompt was the burglary. A lot of people have questions about the burglary, saying that because the store was open, that it is not burglary. It's definitely not burglary at common law, but modern jurisdictions got rid of a lot of those common law elements. Now, do you normally discuss that? Because in law school, I learned to discuss the distinctions, that burglary, you discuss the common law burglary, and then you say something about modern statutes, like the FBI statute and the California statute.
No. I would just.
You don't have to mention, no, you don't have to mention specific statutes, but I was taught that you say modern jurisdictions have done away with some of the elements, so it could be burglary. That's the way I was taught. Is that how you do it? And how does that answer the question of when people say there's not burglary because the store was open?
Let's put it like this. The call to question asks about reasonably be charged. And this actually really happened. I had an open garage when I lived in Newport Beach. I lived on the beach and we had an open garage. It didn't close or anything like that. It was an open garage. 3 kids were caught inside the garage, screwing around, trying to steal something. The police drove by, and you could see the garage from the street. Police drove by, one that could tell something was not right, arrested them, and they actually got charged with burglary. You want to hear the funniest thing is about this story? One of my best friends from law school was the public defender on the case assigned to one of them. And he's like, in confidence, he told me, he's like, fuck those guys. He goes, this guy's up to no good. Like, at least he's, he gets it. So, but, for a Flint, you're mentioning for burglary, you don't need breaking and entering. Well, look, here's the thing. We're going to know the answer to this when the selected answers are released. My guess is, okay, but you said in your example of garage, it's not a public place open to anyone. I understand that, Flint. And the garage is not an open business. I understand that, but do you realize that modern statutes, you can get burglary of a car under some jurisdictions? I know a lot of you don't realize that. I would just, it's a minor thing to mention. I don't know if the examiners were looking for it. I have a weird feeling they were for some reason. Now, there was an essay like this. In fact, I actually have the essay right here. I should, how can I bring it up? Here, I'll show you something. Let me pull it up. Give me a second, and we'll do a screen share. Let's see. Okay, not that one. Nope, not that one. I think it's Criminal Law Crim Pro. 2008. Let me see. There's 2006. Give me a sec. I'm going to show something. Oh, come on. Where's this thing? Where's the one where they both go into the store? Hold on. I'm trying to find an essay for you guys where they actually did not. Okay, I don't know why I can't find it right here. So anyways, there was an essay similar to this that was tested, and for some reason I just can't find it right now. Was it 2011, 2003? Nope. God damn it. It's killing me right now. Okay, so let me go back to the Zoom session. Where are you guys? Okay, so what did I say? Where the same thing happened. Guys went in the store, felony murder, same, same garage, same thing. And they were not looking for burglary. In fact, the call to question even said that they had been charged with robbery because they gave you the underlying felony. Here, they didn't give you the underlying felony. Whether or not it was there or not, I don't know. But I'm not going to risk not putting it in. And it's like, here's the thing. I always tell students, don't just throw everything in there just to throw it in there. But I have a legitimate like concern about whether or not they were looking for burglary. So it's not going to take me more than a minute or two or 2-3 minutes to put it in there. And there's not really a lot here. Could we all agree that this essay, there's really is not a lot here? We would agree with that? Did anybody, and you should probably never do this, but did anyone feel like you kind of finished early or you got it done in a reasonable time and you didn't feel rushed? Anyone not feel rushed, or is that just me hallucinating? Go ahead and shake your heads up and down if you have. So Christy Edson, you so you didn't feel rushed, right? Like it felt just normal.
Sorry, can you repeat the question?
Yeah, how did you feel when you wrote this? I mean, it felt like there was a sufficient, like, you didn't feel constrained, did you?
No, I actually was kind of relieved. This was the first question, so.
Right. Nice way to start the day. Go ahead, Endurance.
Yeah, I think actually I took my time. I was not in a hurry. I took my time to go through every fact. But then again, for the burglary, I was trying to figure out, since you have customers, they said there were other customers in the store. So I just like the breaking and entry element is very difficult for us to prove because you have customers in the store. So that was why I couldn't go with the burglary. I couldn't go with that because they said they have customers in the store. So I couldn't how do I prove the break and entry where you have customers in the store? So I couldn't go with that. I just wanted to raise that issue. Yeah.
I'm sorry, which issue did you raise? I'm sorry, one more time.
Yeah, I said with the bakery and entry, I couldn't go with that with burglary because they have customers in the store at the time of the robbery. They said there were other customers in the store. So I was like, how did they break in if there was customers in the store? So that's why I didn't go burglary.
I think we're beating this burglary thing to death. I shouldn't even mention, like, let's just move past it. Look, it may or may not have been there. Read the selected answers when they come out. That's how we'll know. And whether or not you put it, I don't know. I mean, look, there is no exact science to this.
All right.
But like, so let's move past the burglary thing. I don't want to hear it anymore. All right, go ahead, Sina.
I just want to mention that you mentioned at the beginning, in the call of the question, it says, what crimes could Jim reasonably be charged, not convicted?
Mm-hmm.
So I think a lot of people are just trying to prove the conviction, but that was not the call of the question. So that's my point.
Okay. I mean, look, you can be charged with a myriad of things. Mostly that's charged versus convicted has to do with lesser included offenses. I mean, because you can be charged with larceny. I think what Lauren said about like call number 2 about, aggravated assault. I mean, they'll get him for attempted murder. I just don't see aggravated assault. I really don't think it was there. But that would be a lesser included offense. Technically, he could be convicted of both, or you get charged. I'm sorry, not convicted of both, charged with both. Go ahead, Garrett. We'll go to Garrett and then Francine.
Hi, I'm sorry. Yeah, bear with me. I'm actually sitting in traffic right now, so no video. But yeah, I wanted to just poke fun at myself. I'm not sure, if this came up, but on question 1, I did talk about merger just in the simple sense of establishing larceny would merge into robbery.
Yeah, that's you know what? Yeah, probably a good thing. Yeah. Huh. It's funny. I mentioned at the beginning of doing the essay, I just totally blanked on it because like I see robbery. But yeah, I think that was actually a pretty smart thing to do.
Thank you.
Yeah, I just had to make a note about that because that would be a lesser included offense, and there's a charge. Like I literally just said it, and I just completely went over my head. Go ahead, Francine. What do you got?
I know you said like I may have missed. I've been in and out with the phone and the Zoom, but with murder, I felt like it was like a race horse to get in and on a real discussion of murder to get to felony murder. Was that the right path?
No. I mean, what do you mean? Like, okay, first of all, just as everyone know, every essay is designed to be done in 1 hour. When everyone says racehorse, how about this? Show me a Clydesdale just once, okay? Just show me one essay that's a Clydesdale, please. Look, the whole point of this exam is that it's going to get you thinking on your feet. Can you process a lot of information, be able to compile it, understand it, and then articulate it within a short period of time? That's what this exam is essentially doing. So everyone's going to feel rushed. I mean, that's just normal. It's actually a good thing if you feel rushed. That means you have a lot to say. Students are so overly concerned about like, what if I forget everything? Well, And then the same token, and like the same side of their mouth, they'll end up saying, but I won't have enough time. Well, if you have nothing to say, you're gonna probably have 45 minutes to go. Like you'll be fine if you have nothing to say. But if you have a lot to say and you understand it, then you might run out of time, and that's not a bad thing either. So every essay is designed to be done an hour, and you said it took you a while to get to murder. I'm not quite sure why.
No, it didn't take me a long time to get to murder. What I'm just saying is I established like getting to the felony murder, letting them know common law, and then getting to felony murder in my discussion.
Well, common law and felony murder are the same thing. There was felony murder at common law.
No, I know, but just making the distinction of, and maybe I wasted time with it, but distinguishing between common law murder, 1, 2, premeditation, deliberation.
There were no statutes of common law.
Okay.
And they're not asking for first and second degree here. I wouldn't have gone into it. So just so everyone knows, this is how it works. Murder as the act, killing a human being, and the intent is malice aforethought. Now, what that means is the prosecution has 4 bites at the apple. They can prove intent in 4 different ways. So with arson, they have 2 bites at the apple. They can prove that you acted maliciously or recklessly. For burglary, they have 1 bite at the apple. They have to show that you had the specific intent to commit a crime upon breaking into the structure. Robbery, they have to show you they had a specific intent to take, to permanently deprive them of the good. Okay, but for murder, there's 4 different ways you can find intent. 2 of the ways, first degree. 2 of the other ways, second degree. So when you're talking about felony murder and intent to kill, that's first degree under most jurisdictions. And then depraved heart and intent to cause great bodily injury is second degree. That's it. That's all it is. So, Francine, I don't think you needed to go in that discussion. What was more important was discussing the felony murder aspect of it. Okay, so go ahead, Lauren.
Still learning to use Zoom. Okay, yeah. On this exam, it seemed like it was really looking for a lot of comparisons. On the felony murder, you have 2 murders in that first question. And in one murder, the felon is doing the killing, and in the other murder, it's an innocent person doing the killing. And that's where you get that a red line rule to discuss. But a lot of the essays really had strong comparisons. There was even not to go off of this essay and into another one, but the PR evidence essay had a comparison of evidence. So the lawyer had handling of the evidence, and then the government had handling of the evidence. But in the lawyer's case, it's a professional responsibility issue, and then in the government's case, it's the evidence case. So it's like there's a comparison, like different people handling the evidence. You got to make that comparison, and a lot of comparisons throughout all these questions. I seem to notice that. I don't know if I'm just making up stuff or if it's really there.
No, they do that all the time, and that's one of the things that I mentioned when we were going through it. I had said that what the bar does is they'll never test the exact same issue twice. So you can call it a comparison. I mean, it's a similar issue, but it's a separate issue, or a comparison, however you like to say it. But yeah, I mean, they're going to do that. There's no point of them having, let's just say Jim and Fred went into the store. There's no reason for them to have Jim killing one customer and Fred killing another customer. There's no reason for that. Or having Jim kill 2 customers and have you discuss them separately, because you're just repeating yourself on the same thing. So what the examiners will do, and for those of you that are taking the exam in July and aren't in one-timers, remember that if you're writing about the exact same issue twice, you're missing something. They're not going to test the exact same issue twice. And if you disagree with me, prove it. You think Kim Kardashian published her, like, I'm not picking on Lauren here, but I'm just saying, because I know a lot of, because I get so disgusted when I hear people fall into the trap of believing the nonsense and the bullshit. I do not believe, honestly, that she passed the baby bar. I truly do not. And I think it was her 4th time, is it? Was it her 4th time? Anyone know? Come on, I know you guys, come on.
It was her 4th.
Okay, so does anybody know that, and Lauren, you'll know this, she has to start law school from the beginning. All of her credits, everything she's done has to go reset. She is a first-year law student that has 0 credits. Did you know that? Lauren, am I correct on this?
That is what I thought, but people are telling me different. But that's one of the reasons why I wanted to make sure I passed it the second time. Because I didn't want to lose that. But what they're saying is that if you don't pass the baby bar, you only get credit for the first year. And that you have to pass the baby bar within a certain time. And I'm not really, the logistics, I get a little lost on it. But I knew for me, it's like, I didn't want to have to deal with it again.
Yeah.
So I passed it on the second.
Antonio, I noticed that you have a couple things in the comment, and why don't we have a chat? Antonio Petrella. Anthony, Antonio, unmute yourself and let's talk.
Okay, I'm here. Can you hear me?
Yes, sir.
Okay.
Because I mean, like you're chatting, like, you know, like I'm here for the open discussion, and I can't really do two things at once.
Okay. Well, I'm not going to go back to that burglary thing because that bothered me.
No, we're not going back to that.
Not going back there. But I get the fact that it's where the red line comes in, because the co-defendant was killed in the course of a dangerous felony by a good guy. So the bad guy is not going to be charged with the death of the co-defendant. And I could be wrong on this one, but I also feel that it was justified charging Jim for the death of Chris, because even though it was an accident, I mean, the thing fired accidentally, hit the ground. These things are to be expected when you're dealing with dangerous felonies. Death may.
Yeah. Okay. Wait a second. I was right the first time. Hold on. This is why it's important to read it so many times. So Chris got killed, and he was killed by Jim. Killed Chris. Jim. There's no red line. There's no red line discussion there. I knew I was right. Okay.
Correct.
Yeah.
It was only a red line when the co-defendant got killed.
Yeah. And he was killed by resist, but you don't even need to go to red line, because under the agency theory covers it. So yeah, you don't even need to go to that. Now, does everybody realize? So thank you, Antonio. I had it right the first time. Somehow, I got confused with the fact pattern. And all of a sudden, I thought that Jim killed Fred, not Chris. So Jim did not kill Fred. Jim killed Chris, which is not a co-felon killing a co-felon. So Jim is guilty of felony murder under the agency theory of Chris. End of story, bottom line. Period at the end. There's no other discussion. Jim is not guilty of the Fred because he was killed by a non-agent under the agency theory. Under the proximate cause theory, which is followed by a minority of jurisdictions, he's guilty of both. That's it. End of story. That is the correct analysis. And thanks for pointing that out, Antonio. I did have it right the first time, and then I got confused. And Lauren, even I started getting the facts a little mangled. I kept thinking co-felon 1 killed co-felon 2, but no, co-felon 1 killed victim, then victim killed victim. So, and for victim killed victim, it's not going to be felony murder. All right. So yeah. Okay. Great. And yeah, if those of you who are in the chat box that want to have a discussion, please. That's why I'm here. Okay. And Antonio, you were talking about the officer and probable cause.
Yes, that's correct. Looking nervous is not probable cause.
No.
I didn't read it really good, but you can't pull someone over because they look nervous, much less. And I know we get into that Terry stop later where he patted him down for weapons, but that's a whole other discussion. You really shouldn't have been pulling him over in the first place with no violation. I mean, it was always taught that to police officers, you got to have something to pull someone over with. So if they're they were speeding, they were something, and then you can go to do other things. But this guy had nothing. So, I mean, that's
exactly. Yeah, and and there were two certain things. Flint, let's hear what you have to say. And thanks, Antonio.
Thank you.
I was just agreeing with Antonio. I mean, there's no probable cause to pull him over. There's no reasonable suspicion either. I think I agree with Antonio that you need some sort of probably, moving violation to pull over a car, or probable cause that a crime has been committed, including a misdemeanor.
Yeah, I believe I'd mentioned that when we went through it and how they, there was no reason to pull him over. And I mentioned I did mention how if there was a passenger, the passenger could challenge the stop because the stop was clearly unconstitutional. Funny story, I did run into a motorcycle cop one time, and him and I start chatting, and and this is a fact, within 4 blocks, the average driver will commit a traffic violation within every 4 blocks. And I remember the motorcycle cop showed me, he's like, have you ever seen the vehicle code? He goes, it's that thick for a reason. He goes, that's how many ways I have to pull you over, which I thought was fascinating. So yeah, no probable cause, no reasonable suspicion, unconstitutional stop. The pat down would have been fine because you can pat them down as long as you believe that they might be your safety they might be dangerous. And there's a million reasons to think somebody might be dangerous. This guy was nervous and had a bulge, and that's enough for me. But even though the pat down was legitimate, the unconstitutional stop was not, and therefore the gun will have to be suppressed. Okay, someone else. Go ahead, Lauren. And thank you, Flint.
Okay, on the stop. So I guess we're going back to my law school. I was taught that every fact is there for a reason.
Not every fact. Not every fact.
Well, it depends on how you look at it. Some of them are irrelevant, but I did see something in the facts that after the first crime scene, Jim got home. After the second crime scene, he was just leaving the crime scene. So I thought there was a brief discussion for fleeing felon kind of thing to say that if the officer, because it says in the facts, the officer did not know about the previous crimes. So it's like, I just thought it was a brief discussion. If he knew about the previous crimes, but he didn't. If he knew, then he could say it's a fleeing felon from that second crime scene. I don't remember exactly how I said it. I remember I made a brief discussion about fleeing felon because I saw those facts. And it just made sense that I should discuss them.
Okay, well, when you drove back to his apartment, they make it very, and I'm sure you got this, they make it very clear the felony's over. He is now, the commission of the felony is completely done. Once he reaches a place of temporary safety, and this is more than that. So yeah, I don't know if I would have caught it on the second read or third read, but to me, it didn't even stand out. Temporary. Okay, so I would have, of course, I would have mentioned that because the officer had no knowledge of the events, and I mean, they make that very clear that there is no reason for them to pull him over. There's no exception like the emergency exception or fleeing felon. I mean, I can see how you could bring that up. And there's little intricacies here that, yeah, you could probably, you look at it long enough, you can start seeing things. One thing I do want to talk about to a majority of the group, though, especially for the people that are in my class, about what the graders are actually looking for. And for anybody can tell me, what are the graders looking for? How much time do they spend with your essay? Let me see if for somebody who is not part of one-timers, please raise your hand, and I want you to tell me what you think the graders are looking for and how much time that. I'll have someone else besides Lauren. I was getting someone else in the discussion, but Lauren, I definitely appreciate it. I love having that discussion with you. First of all, does anybody know approximately how long the examiners take reading your essay, or how much they get paid? Someone raise their hand and have a discussion with me about that. Add it back. Go ahead. And by the way, guys, learn how to raise your hand, please, because I'm looking. I can't see everybody because the screen doesn't allow me to have everybody here, and a lot of people don't even have their cameras on. So, somebody who's really not in one to add it back. Okay, I'll go to you first. But Martin, you're not in one-timers. Let's talk to you.
Yeah, they spend no more than 5 minutes.
Okay, and what do you think about that? Do you know how much they get paid, by the way, Martin? Martin, you can unmute yourself.
I'm sorry. What do I think about it? I mean, I think that you
well, first of all, how much do they get paid before you have me answer that one?
So I'm going to take a wild shot. I think somebody said it was like $25 or something like that. I'm not sure.
They get paid $4 an essay, and that's because they just got a raise. It was $3.25. They get paid $4 per essay, $4, and $4 per PT. That's on the State Bar's website. It's a fact. Okay, and 5 minutes. Okay, and so what do you think of that, Martin? How does that make you feel? What do you think they're looking for? What's going on?
I think
by the way, for those of you that aren't one-timers, you're going to be really shocked when you hear what I'm about to say. So pay attention. This is actually really good. Go ahead, Martin.
So you want to know what I think of it? I think that you need to hit all the issues, and I think you need to make them be able to see everything. I think you need to make it stand out. I think you need to underline things, and I think you need to be very, very clear. I think you need to underline things and put things in bold and just walk them through it. You need to be very concise and walk them through it. You need to just.
So let me ask you this, and I'm going to play with you a little bit, Martin. So go with me.
Okay.
What if I showed you a bunch of selected answers that are perfect scores with no headings, no underline, and no bold? What'd you say to that? Or what if I showed you an essay that the issues are laid out for you? There was a remedies essay recently that said call number 1, temporary restraining order, call number 2, injunction, call number 3, permanent injunction, or whatever. It literally had all 3 issues there. Civ Pro, in fact, when Civ Pro on the last 16 of 19 times civil procedure has been tested, they've given you the precise issues they want you to discuss. So you're telling me this is a formatting exam, not a substantive exam? And by the way, Martin, you have the belief that everyone else here has that aren't part of my group, but I'm going to show you. I'm going to have fun with you, so please don't take anything personally. Okay, so what do you think about that, Martin? Like, you have to walk them through it. Have you seen how many selected answers had no headings whatsoever, had nothing bolded, nothing underlined? Have you noticed that?
No, I have seen that in some of the state bar answers, but I just think you need to kind of make it as clear as possible, because they said what I've been told, and what you kind of hear is that they're not going to read it twice, and they're not going to go fishing for things. You kind of got to make it clear to them. That's the best I understood it.
Okay.
But that's the best that I understand it. But I think the last thing I would say is that they have a template, and that you have to hit there's so many issues, and you have to hit each one of them to get a point for each one of those issues that you hit. Murder,
Okay.
felony murder.
Stop right there. There actually is no points in California. They don't add up points. There's no such thing. It's a
Okay.
holistic grading. They don't have time to add up points.
Okay.
They make so many mathematical errors, it wouldn't be funny. Could you imagine getting 5 + 5 + 10 + 50? They'd make too many errors.
Okay, one last question. Is there a checklist of it? You'd have to hit like the certain points: murder, robbery, attempt.
Well, no, because here's the thing. What if you did hit murder? I mean, let me put it like this, Martin. I'll do this. Anybody who missed murder, anybody who took the 2022 February bar exam, if you missed murder, go ahead and say, I missed murder, raise your hand or write it in the chat box. We'll be waiting forever for somebody. Martin, nobody missed murder. So does that mean everybody passed? I don't think anyone missed. Did anyone miss robbery? Did anybody miss conspiracy? Conspiracy, people might have missed conspiracy. Did anybody miss attempted murder? You see, Martin, I think everybody got, let me ask this. Did anybody, and please be honest if you can, anybody not catch one of the issues, whether it's conspiracy, whether it was, forget about burglary. I don't want to hear about burglary. Leave it alone. I'll kick you out of the freaking class if you say burglary. Say that. Say it again. Say what again?
Promise? You promise?
One last
Say
point.
what again? Say what again?
One last thing. I just want to ask you, say for instance, someone had brought up the point, say if you had said, if you threw in red line, would you get points for red line if you threw red line in?
You don't get points, Martin. You don't get points. It's holistic grading. They consider everything as a whole. Now, red line didn't apply here. It didn't apply. You have the agency theory, and one was the agent. I got confused with that. It's not. Don't worry about that one. Don't worry about that one. It was a 1957 Pennsylvania case, Pennsylvania Supreme Court case, obviously, which was a series of 3 cases that came out in Pennsylvania within that 6-year period that dealt with felony murder. But right now we have settled law, agency theory, which is the majority of jurisdictions, which means co-conspirator has to do the killing. If a co-conspirator doesn't do the killing, then there is no murder unless the jurisdiction follows proximate cause. That's it. End of story. I wish I wouldn't have gone down that path. I got confused and I misled you guys on that one. So, Martin, what if I told you? So, do you think the graders read your answer?
Hey, you got me. You got me here. I would hope so. I would hope to give you the 5 minutes. I would hope so.
Okay. Well, here's the thing. I think most graders will probably spend not 5 minutes. I don't know why they would need that much time. I would say 2 to 3 minutes. Probably 3, closer to 3. And for those of you that don't know, Martin, have you ever taken the bar exam before? Martin, you got to unmute yourself, buddy.
This is my first time. I'm 61 years old and I'm disabled, and I'm in Boston, so this is my first time doing it.
All unnecessary information, but thank you for that. Okay, so the answer is no. You haven't taken the bar exam before. Okay, for those of you that have taken the bar exam, and I do this, and I do this on my first class. What if I told you, I will read one of your pen, Martin, you don't, since you haven't taken it, for those of the people that didn't pass it, they've taken a bar previously. I'm sure there's a few people in here that have done that. I can go through one of your essays. I will read everything you wrote. I will tell you what you were thinking. I will tell you when you were right. I will tell you when you were wrong. I will even tell you when you were guessing, when you're bullshitting, you're just trying to throw things in. I'll read your mind as I'm writing it. And I will read their entire essay in generally under 2 minutes, and I will nail their score. And you know why, Martin? Because they know this essay backwards and forwards. First of all, they don't have a template, but they do have 12 hours. How long have we spent with this essay? So far right now, we spent less than an hour with this essay. Do you know how long, Martin, they spend with the essay before they even grade one?
They calibrate, right? They have a calibration and they write it, right?
They don't write it, but they do go through calibration sessions. They have 12 hours with this essay. And here's another thing too. Do you know you have 6th graders?
I don't get that part.
What's that?
I'm not, I'm sort of a little bit thrown off by that.
You have 6th graders. You have 1 grader for essay 1, 1 grader for essay 2, and so on and so forth. 5 essays and 1 PT. So you have 6 different graders. For those people that say like you didn't pass because your grader was having a bad day, I think it was you who was having a bad day. Because you have 6 different graders.
I understand that. I knew that. Sorry.
Yeah, no, Martin, I'm not like speaking. I'm speaking to everyone through you, just FYI. Because I want everyone to be educated. I want them to understand how things work. So thank you for that, Martin, and best of luck in July, by the way.
Thank you so much. Thank you for your time.
All right, so Lauren, what do you got? And then we'll go to endurance.
Well, I was trying to answer the question from earlier. Did anybody miss conspiracy? Yes, I did.
Yeah.
So yeah, I missed conspiracy, but I did on each of the issues that I spotted. One of the things that I was doing was making sure I supported why I was saying that. Like because of these facts or whatever. I mean, I try to support it, and it's like, are they looking for?
Hold on. It's hard to support a conspiracy.
No, I said I missed conspiracy, but on each of the issues that I identified, I put some support as to why I was saying that issue.
What issue?
All the issues on the exam, everything.
Okay, hold on. What I asked was
because you kind of got into the conspiracy and then you started talking. What are they looking for? So you asked 2 questions. I'm trying to ask you 2 questions.
Well, I've listed everything they were looking for. I just asked if anyone didn't get what I had listed, or if they added anything that I didn't. Like you mentioned aggravated assault.
The next, but the next question you asked is, what are they looking for when they grade your essay?
Oh, right. Okay, different topic. Got it. Yeah.
Right. I'm trying to do both at the same time. I'm sorry. I try to break it up.
So go ahead.
So I did miss conspiracy, but when they're looking at the answers, are they looking for support for your claims? I mean, when I made all these claims and I put all the support in there, is that what they're looking for?
And what I meant, this is exactly what they're looking for. I'll say it again. I'll even write it in the chat box. That's all they're looking for. That's it.
I don't know how to get to the chat box.
What's that?
How do I get to the chat box?
All they're looking for is whether or not you applied the law to the facts correctly. If the answer is yes, you'll pass. And I can look at anyone's past essays, and I'll tell you, like, if they didn't, like, if I looked at a previous essay from someone who didn't pass, I will look at it and go, well, you can't pass this because you missed X, Y, and Z. So, and Martin, just for Martin's thing about like drawing attention and catching all the issues, you could literally catch murder and felony murder and still not get any credit for it because you misapplied it. If you say like, oh, it was an accidental killing, it doesn't count. Shit. So yeah, it's the bottom line is it's just whether or not. Oh gosh, I forgot. You apply a lot of the facts correctly. Endurance, go ahead, buddy. Okay, unmute yourself. Okay, Endurance. Okay. Eric, what do you got? I need control.
Yeah, you said something a little bit earlier about how they never test the same issue twice. Could you
On the same essay.
elaborate?
On the same essay.
Essay. Okay.
Yeah. There's no point of testing the exact same issue twice.
So the point there would be, sorry, so the point there would be if there's
testing the same thing twice, you're missing something.
Yeah, got it.
So like here you had felony murder. They tested felony murder twice, but they were testing two different aspects of it. So if you were writing about the exact same thing, you're missing something. You know what I mean? Or if you have because what'll happen, and they do this a lot, when you have two different murders, one murder will be one element of malice aforethought, one murder will be a different element. Or if they're doing negligence, they'll do and this is what they did recently. I think it was within the last couple of years. There were 3 calls of the question. All 3 of them were negligence. So a few people here, I'm sure, are probably rolling their eyes and going, "No, he doesn't know what he's talking about." Well, prove me wrong, because you won't. You can't. You won't. And because even though the 3 calls were negligence, call number 1 had to do it negligence per se and whether or not there was a breach. Call number 2 had to deal with proximate cause, and call number 3 had to do with the extent of the injuries. So they were testing 3 separate areas of negligence. So if you're literally, what I'm trying to do is for people that just use templates and will write the exact same thing over and over again, it never works. Essentially, it's a knock on templates. And again, I'd love it if I always tell this: if somebody can prove me wrong, I'll stop teaching it that way. But no one's you can't prove it wrong because it's not wrong. So anyway, I'm always up. So that's why I have these discussions. That's why with this course, I want to have a discussion with people so that I can explain to them. Like with Martin, we just had the discussion with Martin, and I appreciate him for volunteering and doing that, because everyone has the exact same impressions that he does about what's going on, about how the graders and the headings and all this other stuff, and they're kind of missing the big picture of what they're actually doing, which is why I can go through an essay in 2 minutes and tell somebody what their actual score was and tell them exactly what they were thinking and what they got right and wrong. In fact, if anybody wants me to do that for them, I'd be more than happy to. I welcome it. It's fun for me. It's fun as hell for me. So Eric, hopefully that answers your question. Okay.
It does. Thanks.
All right. So I don't know if there's not much more I can add. I'll stay here till the last person leaves. I know that we lost about 20 people. So if you guys will, I have nothing else to add. It took a very short period of time to get through the essay, which I assumed it would. And this was an easier one, so I felt the discussion probably wasn't going to go too far. But I'll stick around if anybody wants to ask me questions. That's what I'm here for. And if those of you want to tune out, peace. Go ahead, Lauren.
Yeah, just in this discussion, it gets me thinking about some things. One of my goals with all the essays was to make sure that I hit all of the question prompts, that I said something for each of them. But in discussions online, I can see where some people were spending a lot of time on the first prompt with the felony murder and going into the whole second-degree voluntary manslaughter issues, which I didn't do.
No.
And I was just kind of wondering if somebody's spending all that time on those, maybe the first 2 questions, but not giving as much attention to the third one. Did the graders notice that, and what happens?
Okay. First of all, it almost seems like you're implying that each call to question is equal.
I don't know. I think each call the question needs to be answered.
Okay.
To some
But
extent.
that's
I mean,
what
I don't
asked.
think.
You think they're equal? You think they're like 33%, 33%, 33%?
No, and I think you need to look at the facts to know.
Exactly. 100%. In fact, here's something too that I think most people will find interesting. Did you know that they front load the essays? And this is what I mean by that. So first of all, not every call is equal. And that's the thing. A lot of students, and another thing too is stop reading that shit online. Those people, they're idiots. They're absolutely, they're if they had half a fucking brain, they'd be studying. Just so don't read what they're writing. There's no voluntary manslaughter here. There's no heat of passion. There's no imperfect self. There's nothing. There's no reason to discuss that issue. And I think that that's the template brain right there. Like, oh, I got to discuss all that. No, you don't. No, you don't. Because there's not one fact that raises that issue. And if the facts don't raise the issue, it's not a discussion. So in terms of call number one, in my opinion, was by far the most heavy call. In fact, I'd probably give call number one about 60%. I'd give call number three probably, I'd give call number three 25 and call number two 15. That's how I see it. And I actually do those breakdowns in my model answer on terms of like how long you should spend with each call. Eric, have you seen one of the model answers at the end where it's got the breakdown? It's got the percentages next to each call. Yeah, so I do that, Lauren, in terms of that, and I take a lot of things into consideration. I just did it willy-nilly here, but when I actually put the model answer together, I will even look at word count by answer choice A and B and taking out things that were relevant to see what kind of percentage of time they spent on it. And then, so yeah, I think call number one was by far the most important call. And because they front load the essays, that will almost always be the most important call. Not always, but almost always, especially when you have multiple calls of the question. If you have more than two calls of the question, more than two, which this one has, then you can then about an 80% chance, 90% chance, call number one is going to be the most important question, and it's going to be the one you spend the most amount of time with. I'm actually shocked with call number two. There's nothing there. I mean, there's literally nothing there in call two. They just had to put it in chronological order. Call number two should have been call number three. It could have been. And call number three had a little bit more than call number two, but not much more. I mean, there really was. I'm going to be, if there's something in if somebody sees something in call number two that I don't see, please let me know. Please let me know. I just don't see anything but attempted murder. Go ahead and put it in the chat room or raise your hand. So that would be, Lauren, you're on the right track. Let's put it like that. So don't let the fools throw you off. Angela, welcome. Hi, how are you?
Hi.
Good to see you again.
I just wondered, what did the word nervously mean to you?
What does what mean?
The word nervously.
Oh, nervous? The
Did
guy's
it
got
mean volitional? Did it mean unintentional?
It means he got his first grinder date. That's what nervous means to me.
What is it? Sorry, I couldn't hear
said he
that.
has his first grinder date.
Uh-huh.
That would make me nervous. I'm nervous, and you can be nervous for a million reasons. Your wife could be pregnant. You could have got fired from your job. You driving to the bar exam. Nervous to me means, well, okay. Oh, so what they're saying legally? Is there's not enough for probable cause or reasonable suspicion. That's exactly what it's saying. Because just being nervous is not enough. Because think about it, there is a million reasons in the world, I don't understand any of them, to be nervous. But people get nervous all the time over everything, over nothing, actually. So that's just the examiner's way of saying, they'll use the word hunch as well. You know, like, oh, he had a hunch, or they'll use like, nervous is very similar to hunch. So there you go. And Anthony, essays are generally subjective, and they want you to write about it. But here, there's not even a counter argument to being nervous. There's no reasonable suspicion there. But thank you. Good question, Angela. Diana. Hi, Diana. Welcome. Good to have you. You want to meet yourself? Go ahead. And I'll wait for you to find the unmute button. Diana Picerno. Okay. Okay. Okay, Diana is having trouble with the mute button. It's fighting her. Anything else from you guys? Maybe she doesn't realize she just raised her hand. Okay. Go ahead, Martin. And you got to mute yourself, bud. That mute button's a killer. All right.
Yeah, you said you're gonna have these things recorded. When will that be available? The recording thing?
When? I'm sorry. Say it again.
This will be recorded if we want to review it, because I missed some of the analysis. When is it going to be available? The recording?
We should probably have it up in about I don't know, a half an hour after class.
Oh wow, that quick! Thank you so much. And you'll be having more of these classes like in a couple of weeks or something, or?
We'll probably have one like, oh yeah, good question. All right. In the chat box, just write a number. Don't write anything else, but just one, just like literally press the keypad one time. Either do this. What did I say you want to do next? And that other thing. Which one do you want to do next? Everyone, put it in the chat box, and that's what we'll do. And then in a separate, so okay. Oh, keep going, keep going. Everyone. All in a 3-hour lecture. No, I'm not going to do that, Gabrielle. But good suggestion though. I like it. Okay.
Okay, this is Diana. I found the unmute button. Can you hear me?
What technology these days, I'll tell you. Yeah. Oh, yeah, I can hear you. Go ahead.
Question on murder. Okay, when I was reading the fact pattern, I mean, I saw felony murder. Then to talk about felony murder, you need to define murder. Murder is an unlawful killing of another with malice aforethought, and it's comprised by either intent to kill, intent to inflict great bodily harm, depraved heart murder, and then felony murder. I zoom into felony murder. That's what I want to talk about. Do I need to even mention all the other 3 ways of getting the mens rea of malice aforethought, or can I just go straight to felony murder and not discuss the other 3?
I mean, okay, good question. Very good question, actually. So I would put, okay. I would say murder is the killing of a human being with malice aforethought. Malice aforethought can be found in 1 of 4 ways. So I would give the rule statement, and I would probably, within the sentence, go here. Jim can be charged with the death of Chris. Chris was killed during the commission of a felony. Then I would go into, explaining what that is. Then I define murder, and then I go, okay. I would just probably I mean, it's really not even it's a non-issue, but I would say he had no intent to kill or it was an accident. So there was no intent to kill or intent to cause great bodily injury. So therefore, they can't get him on those 2 prongs of malice aforethought, but you could get him under felony murder and possibly depraved heart. So I would go in, I would do a very, very, very quick thing about depraved heart. It was an extremely reckless act. It's devoid of all social utility, which means it has no usefulness in society. Robbing a store, there's no benefit to it, and therefore he could also be found guilty of depraved heart murder. I'd probably just put that in at the end because it is one of the ways they could find it if they don't find felony murder. But they got him dead rights on felony murder, and then I would go into felony murder, and that's why I'd spend a substantial amount of my time. So it doesn't hurt to have a good understanding what murder is and explaining that to the grader, because they're asking you to discuss it. Well, how? Because think about it. Look, Diana, think about this. You probably have friends or a spouse or whatnot that didn't go to law school, correct? Or parents? Diana, you have to unmute yourself, sweetie.
Yes, of course, yeah.
What if they asked you, hey, can this guy there was a robbery down at the store at the 7-Eleven, and one of the customers got killed, but he didn't shoot him. It was an accident. How does that work? Are you going to be able to explain that to them?
Can you say that again? I was trying to figure out the whole mute thing. This is my first time with Zoom and the phone. It's like the buttons disappear and I'm swiping.
Okay. Thank you. All right. So yeah, it really, okay. If one of your friends who's not a lawyer, never been to law school, said to you, hey, the store down the street, the 7-Eleven just got robbed. And this guy's being charged with murder, but he didn't kill, it was an accident. He just dropped the gun and the gun was charged. Can they charge him with murder? What are you going to say?
Well, I would explain to them what murder is, and that to find murder, the mens rea is malice aforethought, and the fact that he
would you explain to your friend that even though he didn't intend to kill him, he could still be found guilty of murder because it occurred during the commission of a robbery? Would you say that?
Right. Yes, that's it. That's what I was working my way to. Yes.
Well, now you have your answer.
Okay, thank you.
You see what I mean? You see what we just did?
Yes.
You're discussing it with your friend. and it's just, this is just a state licensing exam to see if you're ready to become an attorney. So if you can discuss it with your friend, you can discuss it with the grader. It's the exact same thing. It doesn't change, because your friend's going to want to know, wait a second, how can you be charged with murder? He didn't, it was an accident. And then you would explain, well, even though you didn't intend to kill him, they can still get him there, because one of the 4 ways to find someone guilty. You see what I'm doing? I am literally just doing exactly what you would do with a grader. That's what the bar exam is. Have you ever seen the movie Philadelphia? Or go, what you say?
No.
No, go, please. I cut you off.
Oops. No, I see what you're saying. Thank you. You integrated, like, without having to break an next element, you integrated that all.
Mary, turn your shit off.
No, no, I'm not interested in.
Mary, turn your shit off. Ethan, get her out of here.
Okay, come here. What do you want to see? I want to see you guys.
Ethan, get her out of here, please.
Come here. I'll show you the video. Oh, there's something there's a video. Yeah.
Ethan.
Hold on, let me find it.
Mary, turn your shit off.
Yeah.
Rude and disrespect. Ethan, get her out of here. Thank you.
Oh, but no, thank you for explaining that, because that makes sense. Instead of breaking out each separate element, like intent to inflict great bodily, it's not there. So I would just go straight to, even though he didn't intend to kill, he could still be charged with murder through depraved heart murder. Okay, got it.
Yeah,
Thank you.
You don't need to go in this whole flowery. You don't need to like break up every little thing. I mean, you can. There is no formalistic way to write this exam. You can write it as long as you just explain it, and that's the whole thing. If you look at all the selected answers, a lot of them are very conversational. It's just you having a discussion with the grader, just like you would with your friend. And there's one other thing I wanted to add to you about shit. Forgot what it was. Oh well. If it comes to me, I'll let you know. Cervantes, and thank you very much, Diana. I hope that made sense to you. Cervantes, what do you think?
Hi, Jason. It's a pleasure to virtually meet you. And I'm so happy that you hosted this. This is my first time attending one of your sessions. I actually was curious about your thoughts about, how people, so there's statistics out there that repeaters have less of a probability to pass. And I wanted to get your insight as to why and what factors come into play for those statistics.
That's a pretty easy answer, believe it or not. Okay, so think about this. When you start law school, and a majority of people, probably a small majority, they go right from like high school, college, to law school. I didn't personally, but I know that's a path for a lot of people. All right, so you're literally in school the entire time. What happens after you take the July bar? For those of you that just take it out, for those of you that follow that path, what happens? And if you think about this, Erica, most people will go to a law, will try to get a job. Hey, now I got to work. And they go get a job, and they haven't been studying for this long gap between July and November. And as you know, your memory kind of like starts fading. If you don't, you use it or lose it. So they haven't thought about school. They haven't read anything like with the bar exam. They haven't looked at any of the material. Now, if they get the results back and they pass, well, they've now started their lives. They're generally working full time. They can't take off the same amount of time they did after law school because now they've got to earn a living. They've stayed away from it for so long. They're usually not as motivated because, it's a little bit, I'm not saying it's harder to do it a second time, but, some people just don't have the motivation. Then you have the holidays going on. So like, well, I'll do it after Thanksgiving, and they'll usually push it off until after Christmas. They're working full time and this, that, and the other thing. And then another thing, if you didn't get it the first time, most people don't do anything different. I see students who I had one student who failed the bar 16 times, took my course, passed on the 17th try because she finally did something different. And there's Sherry Foglio, Foglio, Sherry Foglio. And there have been a lot of people that I just they do not break the pattern. They just think I got to memorize better. That's not what the exam's about. So to me, it's almost like a clear why statistically it goes down. Again, you're starting your life, you've got that big gap in time, you're generally working, and you didn't change anything. So I think that would be the answer. Does that help, Erica? Do you think that would be a reasonable way to look at it?
I appreciate your insight. You answered my question. Thanks.
I mean, would you agree with that? Or do you think there's maybe something else I'm missing or I'm not seeing or whatnot? Because obviously it's my opinion, it's not based in fact.
No, yeah, and I mean, I've always inquired like on YouTube or from other people or from professors, and the one thing I do always hear is people don't change their habits, their study habits.
Oh
So
my
that-
God. Do you have
Mhm.
any idea how hard it is for me to break some of the things they'll hold on to that template and that checklist, like Linus held onto his blanket. I'm just like, fucking let it go. Like, here's the thing. Let me ask you this, Erica. Do you really need a checklist to tell you that somebody got killed during a robbery?
No.
No. But they do. It's like they think they do. And that's why I hold these sessions, is to show you, like, look, you can't miss anything if you do it. Well, excuse me. You won't miss anything big. Oh, you're always going to miss tiny little things. Shit, I miss tiny things all the time, which is why I've never been published, as far as I know. Of course, I could lie to you and tell you I have, but I've got too much credibility and integrity to do that. So I always miss little things, but I've never missed anything big. It's impossible when you go through the fact pattern like this, especially when you go through it 2 or 3 times. So there you go. Now, most people, they don't even read, they read the fact pattern one time extremely fast and they start writing. And that is not a way to answer a question. I need to process it before I start writing. So hopefully that helps. Okay, Anita, we have you. You're new, so I'm going to go to you first. How you doing?
Hi, nice to meet you. I didn't plan on signing on for this today, but I just saw it at the last minute, and so I decided to take a chance. And I was just going to say, yeah, I 100% agree with you. I graduated law school in 2005. I missed the bar 2 or 3 times by less than 9 points. I kept getting a 1431.2, 0.8, and then I had to move on with life. And then you can try to retake it, but you know your employer is not going to be forgiving. So there's other factors too. You know, later I was diagnosed with something similar to MS, so it's crazy that I even got close. But now I'm working. I finally just got diagnosed at 45 years old, and I'm going to try to retake it. So for everyone that's out there, I would say if you have the chance now to do this, and I'm sorry, I like you, and I think he's somebody you could learn from. I definitely think take a chance, do it now before you move on with life. And even if you are a repeater, I'm gonna do it, and despite my condition, because I got so close when I was younger and undiagnosed. So
I hear that one-timers guy's pretty good, so you might want to look into that if you're serious about passing.
yeah, so I encourage everyone to do it. I'm going to do it, and if I can do it with my myasthenia gravis, y'all can do it.
Appreciate that. Antonio, I thank you for that. Antonio, what do you got, bud?
There we go. Can you hear me?
Yeah. Yeah, go ahead.
I forget who it is now. The guy that. But I was thinking also maybe something like, not that I wouldn't think of this, intimidation of a witness, or because he's trying to kill a witness to the crime.
Okay, but there's no constitution that would be forfeiture by wrongdoing if you killed them from testifying, but they're not asking about that. I'm sorry, what was your question, Antonio?
So I wouldn't have thought of that. I would go with the attempted murder, but I'm thinking, oh, he's also trying to prevent a witness from testifying or intimidating a witness. I don't know what the exact thing is called, but
intimidating a witness. Okay, so there's a constitutional provision on the 6th Amendment of Confrontation Clause where it's called forfeiture by wrongdoing, where you can't kill somebody to prevent them from testifying.
Right.
But that's the constitutional issue and evidentiary issue, which is not. They asked about crimes. And yeah, you could go like intimidating a witness, or they're not testing that. They're not testing the California Penal Code. That's not there.
Yeah, I wouldn't have put that in anyway. I just thought of it now because I had nothing better to do.
Well, they generally confine themselves into certain areas, and they're not going to make you like, you're not going to, Although I did see on an MBE recently, one of the answer choices was identity theft, which I thought was pretty neat. It wasn't the correct answer, but it was like a really cool answer.
May I ask you one more thing before I let you go? Getting back, and I'm one of those people who would have forgotten that conspiracy to mention that, because I would have jumped right in. Oh, this is a felony murder, blah 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 blah, and forgot all about. Well, they conspired to begin with. So I guess my question to you is like, if I would have forgotten that, but I still would have did a good job with the that stuff, would that have like, dummy didn't get conspiracy, he flunks, you know?
No, you're not gonna fail from missing one issue. Second of all, I thought you were gonna ask me how can you prevent that from happening, and it's simple.
Yes, how can you prevent that from happening?
Simple. Fucking slow down and read carefully, for God's sake. This test is really testing your ability to read carefully and answer the call to question. I mean, and another thing too, which you probably don't know, Antonio, every single conspiracy they've ever tested has always been in the first or second sentence. And same thing with quasi-community property. Well, scratch it. They did it one time when it was the second paragraph. But Antonio, watch this. Go back through the criminal law essays and you'll see in the first or second sentence, that's when the conspiracy happens. First or second sentence, every time. So, if you had somebody who's teaching you these things and pointing these things out, you will never miss it. Or at least you should never miss it. I mean, people are going to make mistakes. It happens. There's a lot of information. You're not going to remember everything. But whenever I see from criminal law essays, whenever I see two guys acting together with anything, I just know it's going to be a conspiracy or accomplice. And also, I know it's also one of the most heavily tested issues they do put together. So by reading carefully and by thinking at the end of every sentence and really slowing down and then reading it 2, 3, 4 times, you shouldn't miss it. But what you just said, which is interesting, you said, I just jumped into, yeah, exactly. There you go. You're not acting like a lawyer. You're acting like somebody who's nervous. You know what I mean?
Yes, sir.
But and thank you for being like, a lot of things too is like, I'm not, and I appreciate you being vulnerable and open up to criticism and discussion because I'm here to help you. I'm not here to make anyone feel bad, and my job, I love teaching. When I was in high school, that counselor says to you, if you had $1 million, what would you do for the rest? I gotta teach. I've always wanted to teach. So actually I enjoy this. And there's a reason why I'm holding this class for my students and for anyone else who wants to join as a courtesy. And I'm going to do all of them. I'll do all the essays just because I want to go through them. I actually love this stuff. I love this stuff. I've taken the bar in 13 different states and they prevent me from taking the bar again. And I'm pissed off. So if you're taking the bar exam and I look like you, let me take it for you in July, please. Anything. So I actually enjoy the exam. Okay, thanks, Anthony. And endurance, what do you got?
Yeah. Yes. I just want to agree with you on the conspiracy. Because at first I almost missed it. I think like you said, first paragraph. I think it was said first statement. He said they armed themselves. I think that when I got it, I said that's conspiracy because he said they armed themselves. So I got it right there. So thanks for that. Then for the other issue, you said aggravated assault. I think I was able to go back to 2010, July and 2010, California Bison. I saw.
Right, I think hold on. I missed what you said there. Could you do that?
Yeah, I'm here. 2010 for July 2010.
July 2010. Okay, I got the essay right here. Go ahead.
I think there's the issue has to do with battery or aggravated assault. I just want to read that.
2010. Here, I got it right here. Hold on. Yeah. July 2010. Fourth Amendment warrant requirements, checkpoints, Terry stop, booking search, exclusionary rule, independent source, inevitable discovery, purging the king, guilty pleas, kidnapping. Oh, there was attempt. What the hell? How did attempt get there? Attempt. Oh, yeah, of course, attempt. I thought it was assault. So that's what they were testing in 2010, July, question 5. There was no battery.
Okay. All right. Just want to be sure about that. All right.
I mean, because I know that most people don't spend the amount of time I spend with one essay. Generally, when I write a model answer to my essays, by the way, a question for you. How long do you think it takes me to write a model answer to an essay? Endurance.
Read time. I'm doing okay. Probably I would say like an hour or 45 minutes.
Takes me 2 to 3 days. 2 to 3 days it takes me to write a model answer. That's how long I spend with an essay. Now I could probably knock it down to 2 days now. But I just research everything to like a totally different degree. So that's how I know when I tell you it's not there, it's not there. Because I know
but for me, it's not like a major issue. I just threw it in, not like a major issue for me. I think the major issues for me, like the conspiracy, robbery, felony murder, depraved acts, I just treat it like a minor issue. Like I have like sufficient time, so I have to throw it there. It's not like a major issue for me.
If you put something in, like, for example, let's just assume they weren't looking for burglary here, which I think is, it could be, I think it can go either way. I really think it's 50-50 on whether or not they were looking for it. I will know when the selected answers get released. So I look at it like this. I'd rather not miss discussion of that topic. I'll sacrifice the time for the accuracy. You know what I mean? Because it's not going to take me and I'm not going to list every freaking element of burglary and go through. I'm not going to do that. I'm going to just say common law burglary required a dwelling at night. Here, we don't know what time it is. And they're not breaking into a dwelling, they're breaking into the store. Although they wouldn't be found guilty at common law of burglary, they could modernly be convicted of commercial burglary or some lesser offense, because most jurisdictions apply it to structures and to any type of the day. That's exactly how I would do it. It'd be 3 or 4 sentences and I wouldn't think twice about it. But I would rather do that than not do that. You make sense?
That's right.
I'm not gonna spend 15 minutes on something that's questionable on whether it's there. I will spend 15 minutes on felony murder, because guess what the most important issue on this exam, this particular essay is? Felony murder. Boom.
All right. Correct. Actually took all my time. Yeah. All right.
You're welcome, man. What's going on?
Hi, Jason. So I just want to go back really quick to the conversation. Can you hear me okay?
Oh, absolutely.
Okay, great. So I wanted to go back really quick to the conversation about the memorizing of rules and checklists. When I first joined your class, I thought you were crazy. I was like,
right?
Yes, I thought you had got to be freaking kidding me. The whole time I went to law school, I had to have a checklist and rules. And you wrote that checklist down really, really fast right before you took the bar. Boom, right there, right? Okay. I agree with you 100%. I just took the bar. Let me tell you something. First of all, I've been with you for a little time. I withdrew from the bar the first time because once I started your program, I realized I did not understand the law. I had to go back to law school with your program first. So now that I've done that and I just took the bar, I needed no checklist. I didn't have to memorize rules. I just explained. I explained the facts to the law, right? And so, like you said, when you was talking to that young lady about explain it like you're talking to your friend, if you're not memorizing rules and you're not memorizing checklists, what are you memorizing? Concepts. It was concept after concept. And the way your program is set up between the multi-states, the outlines, and the way you break down the outline, the essays line by line in red, there's no way you're not going to understand what each line meant once you get through each outline. So my point is, even if you don't read the outline, even if you haven't done multiple choice, just doing the essays, the way you break them down, you already got it. You don't have to go back and learn it and memorize it, learn it. You understand conceptually what is happening and you can move on to the next thing, which made my digesting of learning your material much, much easier. Thank you, my hackles. Off to you.
I appreciate that. And by the way, for those of you that weren't in my course, go ahead and click on the link that I put in the chat box if you haven't already done so. And if you want to know how to write for the bar exam, there's your answer. It's that simple. Go ahead, I think you might have seen this one before.
It's okay. I can see it again. I can't say that I passed. And I think I wrote you an email stating, look, if I didn't pass, I'm right out the door, though, because it took me time to go back and honestly redo law school with your whole program, because the way I learned law school is completely different than the bar. Completely different. So the way your program is, I got it. I got it now.
Unfortunately, I was talking to the owner of Bar Essays last night about this, and we both agreed that the law schools drop the ball and don't properly teach students.
Yes.
I hear things that professors and deans say all the time that are unequivocally false. And the thing is, they're not trying to mislead anybody. They just don't know better. And they don't have, think about this, for those of you that don't know me, and if you've ever taken a bar exam, you're not exactly in the clearest mindset when you're taking it. Everything's just coming at you, and you know, you spend all that 2.5 months of just cramming things in there, and you know, and it's just a blur. It's just a blur for most people the first time. Those are the people that are teaching you. Think about it. Those are the same people that were selling their soul to the devil right before 6 o'clock on Friday are the ones that are leading the law schools. They have no, and it's been 30 years since they've done it, which is still frustrating to me. Like, I do this stuff all day, every day, all the time, nonstop. I keep taking the bar for a reason because I want to, I don't know. I just love this test for some reason. It's been good to me, and so whatever. But I just realized, like, when somebody gives you advice, this is the best thing I could say. Check the source. Check the source of the information. Who's telling me this? Is it Ray Hayden, who's failed the bar 11 times, like 4 there and 7 there? If he's the one giving the information, it's probably not that credible. Like I wouldn't want to take, I wouldn't ask Stevie Wonder what the Louvre looked like or how that Picasso painting was colorful. He's not the right guy to ask. He just can't see. So maybe somebody check the source of who's telling you the information and what makes them an expert. So yeah.
I have one more thing to say. Before I signed up with your program, I actually purchased some Barbie books. Barbie has way too much information. There was so much information, not to say all the laws or information wasn't there, but it was all there. It was there, that and a bag of chips and a 6-pack. It was just way too much information. The difference between Barbie and your program, as I saw, you only put what's on the bar. I didn't need to see this, and this, and the third. I only saw what was on the bar. So let me
semi-secret trust, anti-lapse, federal preemption.
Right. So let me tell you one more thing. So the checklist situation, as far as memorizing rules, I got that from Fleming's. The checklist, the memorizing rules. Oh my God, it was just way too much. So I just took the bar. Everything that you had in your program was on the bar. There was no surprises whatsoever at all. Like, it was all there. I was just shocked. Every time I opened up something, I got to a multi-state, I did an essay. I was like, oh my God, like, it was all there. Thank you.
I appreciate everything you're saying. People are going to start thinking I paid you. So.
Okay. I'm sorry, you guys. He didn't pay me. But it's just that I'm so excited. That's all. I'm just really excited. Sorry about that.
I do.
I'm gonna move myself.
I really do appreciate that, and I thank you very much.
I'm just shocked. I'm sorry. I'm just shocked because I did go through a couple other. I'm just shocked. That's all. So forgive my shock. Forgive my shockness.
And it's hard. By the way, for those of you that are about to take the course or whatever, having people buy in, nobody buys in at the beginning. They're like, because everything I tell them is generally the opposite from what they've been previously told and sold. And by the people that don't know any better, it's like, wait, he can't be right. And then I prove it over and over. Like Martin was a good sport by he thinks the headings and the bolding and the underline because that's what he's been told. That is not correct. Now, I'm not saying put it in a coherent manner, or if you want to do that, that's a good way to even the Supreme Court does that with issues. They'll separate issue by issue by issue, which I think is a good idea. I'm not saying it's a bad idea, but it's not what makes or breaks your grade. In fact, I do it. Antonio, you wrote about killing off the rule against perpetuities. Do you know that's not tested? Antonio? They've already killed it. Where's that?
Wasn't MBEs.
Here I am.
Okay, who said it? Jake, you're saying was it in the MBEs?
2-3 times.
No. Okay, no. One time, from one time that I know of for sure, they had a call to question that said the rule against perpetuities is unmodified in this jurisdiction, and the only reason they put that is to have a wrong answer in there. Aha. But you said it was a second time. Wouldn't it be 3 times? Because they only have 5 questions in section number 1, and they can't use all of them for future interest.
They brought it up. I know they brought it up at least twice in the MBEs.
Anybody else can confirm or deny that? I know it was once, but it wasn't. They were not testing the rule. Oh, they were testing, but it was
3 times. But I know it was at least twice. It was brought up.
Okay, the one time with didn't have the guy was during his lifetime. You didn't even have to go into it. It was a non-issue. But yeah, they mentioned it, but they weren't testing it. Okay, because they don't generally. But you're right, though. I know what you're saying, Jake. I know what you're saying. Because people are like, oh, well, they also don't. there's certain things they don't test, but they'll mention. Like they mention identity theft, but they're not testing it. They generally don't test force majeure clauses, but it'll be in an answer choice. But yeah, so I hear what you're saying. And Jake, I appreciate you pointing that out because that clears up inconsistency of what I was saying. What I mean to say is, I should clarify it, is you don't need to know anything about it to succeed, for the most part. And if anything, there'll be one MBE question on it, but it's not worth your time. And the way I look, go ahead, Anthony. Antonio, go ahead.
No. I was just that like on samples of essays. I've never seen that, and I always think, oh, great, I'm glad, because it seems like a lot of time to put into something there. It's like, why bother? So
Okay.
anyway,
You want to know why law schools do that? Actually, I read a law review article about that, and it made complete sense to me. Do you know why law schools do it?
No, why?
They're training. It's the same reason why people flip tires and why they do all the things in CrossFit that they do. You don't need to flip a tire. Nobody needs to flip a tire, but they do that because they're training your mind. It's like they're training your body. So if you can understand obscure concepts that you have no ability to relate to, then you can think through things that you can. Think about with the LSAT. I had a lot of trouble with the LSAT because I couldn't, when I say like all zygotes or zebras, I'm like, what the fuck? I couldn't process my mind to relate it to something that made any kind of logical sense to me. The bar exam makes completely logical sense to me because it's real life, it's real facts, it's real things, where I felt the LSAT wasn't. So with the rule against perpetuities and future interest, if you're able to understand obscure concepts, and that's why they do it to you, is that we can get you to think through anything if we can get you to think through this. And a little rule of thumb, the rule against perpetuities only applies to interests that revert back, that go from grantee to grantee. It'll never apply to an interest that goes back to the grantor. FYI.
Right. No, it doesn't. It doesn't account for the reversionary interest, right? Or yeah.
So the way they're going to test it was an executory interest. There you go. And executory interest means it cuts cuts the grantee's rights off, gives it to another grantee, and that's what actually happened in the fact pattern. And this is the way they generally test it, and it'll generally be within the life or whatever.
My issue with that was, if I had 10 to 15 minutes, because I have to reread it a million times, I can get the right answer in the rule against perpetuity. I've got 90 seconds, not so much.
Here's the thing too, the questions that I even know what questions you're referring to. So realize something, back when the MBEs came into existence in 72 and 73, and I think they're thinking about going back to this. This is one of the proposals for the 2026 bar exam. Is the reason why those questions are so long, Antonio, is there used to be one large fact pattern, almost like this for an MBE question, just like how the essay is, but there'd be like 4 or 5 different stems. So you see how we have 3 calls of the question in this fact pattern?
Yes.
Well, the MBE used to have one long, very long fact pattern, and then 4, 5, or 6 calls of the question. So you're only doing what courses have done, including myself, although I've edited them down. Other courses haven't edited them down, and they'll take that original question and they'll make it into one. They'll just cut it, but they'll just take the same template. Like, see, if I was going to cut this essay down, I would take paragraph number 1, put it to call number 1. I would take paragraph number 2. Well, yeah, you can put paragraph number 2 to call number 2 with a little bit of editing, and then call number 3 to paragraph number 3 to call number 3. You see, I can make this into 3 MBE questions, or one essay. So that's why you're doing those long ones. Skip those if you haven't taken the bar, if you end up taking it again or whatever the case is. Don't go through those questions. I won't let my students go through them.
Oh, good advice. Thank you.
Got it, man. Lauren, what do you got?
Hello. Yeah, okay, so, well, now I have 3 things because it's been a while. Well, first off, on the MBE, I didn't know that started in 72 and 73, but I do remember I'm old enough, I do remember multiple choice questions when I was a kid, and they did have that long paragraph, and then you have the different questions at the end related to that long paragraph, but then later, somewhere along the lines, those multiple choice questions changed, so it's just one question. So it's like, that might have been just, I mean, that change that you discussed might have been just the way multiple choice questions were written or something, but I didn't know about that. The early MBEs being like that. So, well, thanks for the information. I thought that's fascinating. Yeah.
I have a lot of useless information about the bar exam, by the way. I've got more
I
things.
love it. Oh, I just love it. And I love the bar exam when I'm not taking it. So it's like, I hope I don't need your services. Well, no one may sick. Anyway, so I did have two other things to discuss. One of them was about the various controversy. I mean, you've mentioned people, I'm not repeating names, but various controversy about the bar exam itself as though it's a fraud. And I wanted your opinion. And then I also have another one that's just kind of a little amusing. I thought it was an amusing story of a Perry Mason episode just before the bar exam. So I didn't know.
Let's go to the first issue. Hold on, let's do one thing at a time.
I understand what you said. I'm just telling you I had to. Go ahead.
Well, I know you have two, but let's address the first one. So you asking me if the bar is a fraud or what I think about those people that are doing that.
Right. I believe the bar exam is valid and it does have relevance to the practice of law or testing competence or whatever, but I wanted your opinion.
Realize I make my living off the bar exam, so I'm gonna have a biased opinion. However, I do, and this is even before I started one-timer. I started one-timers 1 year after I had passed the California bar exam. I think it's an excellent measure of ability to think. I think, hold on, okay, I see things on the chat logs. And by the way, Norman, if you want, just raise your hand by putting the reaction thing in, and I'll get to you. And we can talk about that. The essay portion we did in the first 10 minutes, yeah. So you can watch that when we post a little bit later. Ethan will do that. So I think those are the little snowflake social justice warriors that are just whining about every fucking thing. I think the exam is actually too easy now. I don't think it should be $13.90. I think that is a disservice. And for those people that, if you think that California, I mean, even if I think California is easy, it's still the hardest bar in the country. I know. I mean, by the way, for most people that don't know this, who here knows or has an idea of what the second hardest bar is? Anybody have an idea?
Delaware.
Go ahead, Eric, go say it.
Delaware.
No, but okay.
Is it in New York?
Fuck no, New York's the 8th easiest. I knew you were gonna say that. New York is the 8th. New York is the 8th easiest. Watch this. I'll show you guys. And don't take my word for it. Let's look at objective evidence, because I don't say anything without backing it up. Go ahead and click on the link that I just sent you. Now, go to, somebody tell me out loud, Lauren, go ahead and tell me, what score do you need? What's the highest score you need to pass every state but 10?
Oh, God.
Alaska.
80 for Alaska, yes.
Okay, and look what, okay, let's go to the 260s. We have 5 states there. Those are the 5 easiest states: Alabama, Minnesota, Missouri, New Mexico, North Carolina. Okay, that's 5. 6 and 7 are Indiana, Oklahoma. And look who's number 8. 8th easiest, New York.
Yeah.
How about that?
All righty.
So I don't tell people things. I don't say things without having something to back up with what I'm saying. Because that's why with the whole Kim Kardashian, show me proof. I am not talking to you, Lauren. I'm speaking to the world. Before anybody makes any claims, show me proof. If I can disprove something, like for example, the whole thing about headings and bolding and underline and all that stuff. If I can show you a selected answer, I got a perfect score and more than one without any headings, I've seen a selected answer with almost no rule statements. And I do this in my course. It's brilliantly written. It just didn't have anything. It didn't have like any formal rule statements or any I saw one rule statement of a selected answer that says, the duty of competence requires a learner to be competent. That was the rule statement, which is fine. So I don't say anything without backing up. So if I can disprove something, it can't be true. But anyways, okay. And now, second question.
My comment on New York is because when, like I said, I'm old. When John F. Kennedy Jr. was taking the bar exam,
Lauren,
it took him like 3 tries to pass New York.
Lauren, If I was banging my Marilyn Monroe, do you think I'd be here right now?
Son, I was talking
What's
about
that?
the son. The son, the John F. Kennedy Jr.
Yeah. Oh my
He
God.
didn't date Marilyn Monroe. She was dead by the time he was born or something. I don't know.
Didn't JFK date Marilyn Monroe?
Junior, the son, Junior,
Oh.
the father's son. The son, when he took the New York bar exam, he had a hard time passing, and people were saying at the time, "Oh, it's the second hardest bar exam, or it's almost harder than California." It's like whatever, but that's the only reason I said it. I don't study the bar exams. Anywho,
Yeah.
that's irrelevant.
Yeah, I think the reason why, and you have to look at other factors too. Why Kim? Do you know, like when I sat for the bar in California, I actually sat on the same bar, not the same place, but at the same time, with the dean of Stanford Law School. The dean of Stanford Law School. I remember my mom sent me the article about about 2 months before the exam. I'm like, did you really need to send me this? The dean of Stanford Law School had failed the July 05 bar exam and sat for the February 06 and passed that. Well, why is that? Why did Kim Kardashian fail 4 times? Why did John Kennedy Sr., which by the way, I did not know that, but I like to say that he's probably banging Marilyn Monroe too, give him that. Because they have other things going on in life. You know, they have, and here's another thing too, Lauren. Did you ever see the movie Catch Me If You Can?
No, I don't watch movies.
Anybody know of the movie Catch Me If You Can? Where he'd passed the bar exam in Louisiana. Do you know he actually failed it twice? He passed on the 3rd try. They don't see that in the movie, but he did what I teach. He reverse engineered it. He saw what he did wrong and learned what to do right, which is he did the review process. Yeah. So, okay. And your second question was?
My second wasn't a question. It was that this is just, I thought it was an amusing thing. The day before the bar exam, I had Perry Mason on TV as I'm making breakfast, and Perry talks to his detective, Paul Drake. Well, they have a murder in a burning building, and Perry discusses the felony murder rule, and it's arson. And he was saying, it's like, well, felony murder, he was talking about malice aforethought, and then Paul Drake chimes in, oh, and then the malice of the felony becomes malice aforethought. And I thought, yeah, that was cool. I just like the way they stated the rule, even though that's going back to like the 50s. And I was really hopeful that there would be a felony murder on the bar exam, just so I could try to reuse that rule a little bit and try not to trash it. But I thought that was funny that the felony murder was on TV the day before the bar exam, and I had the felony murder there. I just thought it was cool.
That is kind of cool. I like that. Now also, I like that. We had somebody who came in late that had a question, and I believe that was Norman. And by the way, Len Breb or whatever, is that really your name? I don't think that's really your name. And NS Kearney and 510. I'd probably cut those people. I don't know who they are. Okay, so Norman, is that your real name? I guess Norman's out. Yeah, Norman left. Okay, so yeah, you come in 2 hours late, probably been through the essay already. Okay, anybody else have anything to add? I'm gonna take off, watch the Nets game. Anyone? Going once.
This was great, Jason. Thank you.
I appreciate it, Rose.
How do we find the recording? I'm sorry I didn't raise hand, but how do we find the recording? Is it on the Facebook page?
I think it will be.
Yeah, it'll be on the Facebook page more than likely, but it'll probably be a link to the YouTube because it's going to be the length of it. But it'll be available sometime tonight. It'll probably take a few hours for it to get rendered and uploaded.
Oh, even tomorrow's fine. But you people, I'm sorry to interrupt you. You have a YouTube page?
Yes.
Okay, you guys are wonderful. I thank you so much. This is very helpful. I wish you the best, and hopefully we'll get more. See you again. Thank you so much.
Martin, we'll probably do the next one either tomorrow or Friday.
Tomorrow or Friday. Oh, this will be great. So I look forward to it.
Yeah.
Thank you very, very much. This has been excellent. Thank you.
Thanks, man. Appreciate
Happy
it.
to help.
Yeah, and Ethan, when you post the description, let them know, like, we pretty much finished, like, how long did it take, Christine? Do you remember how long it took? I mean, it didn't take more than 20 minutes.
No more than 20, 25. Yeah.
Yeah. So the rest of this like kind of like nonsensical discussion, which is fine. I think we actually will do it Friday though, only because I want to give people a day, like, you know, they might not catch it, but anyways, what do you guys think? Matt, Christine, Rosa, my students, Edson, you guys are the ones
Yeah.
I mostly care about.
Friday works
Yeah.
for me.
Yeah, Friday's good.
Friday
Jason.
works.
I can do either.
All right,
Which
we'll do-
essay? Which essay is it?
I don't know. What do you want to do, Martin?
Oh, I'm the flexible one. Whatever anybody else wants to do, I'm the flexible one.
These monsters want to do essay 5, so
4 or 5, yeah.
4 or
4
5.
or 5. 4 or 5. 4 was interesting.
I think I should make you guys wait, and then you can only do 4 or 5 if you go through the first 3 levels. Aha! Got to build my audience.
That's fine. I'll review.
That's
all of
actually
them.
a
I'm
good,
with that.
that's a good, yeah. I'm fine.
I was reviewing all of them, so yes.
Oh, I haven't got through them yet. Because I kind of like, you know, I told Ethan, I go, when the essay's released, it's like I'm like a kid on Christmas. I just want to like run down and open up the presents, but I waited for you guys so you can see me go through it, because like I think going through the raw version of things is better. And you guys saw me. You really saw things raw in July when I was going through the MBE questions that I had never done before.
Yeah,
and I think that was that was a lesson in humility. I'll tell you that much. But it's funny. My folks were watching that, and they were laughing their asses off. Anyways, you guys have been great. Thank you very much. I hope everyone did enjoy it. And if you have anything else you want Ethan or I to know, feel free to let us know. You hit me up. You know how to reach me. Okay.
Thank you, Jason.
Thanks,
And
Jason.
for I'll just do another thing too. If anybody who's not like, you can always email administration at one-timers, admin at one-timers to request anything like Martin, if you want to know where that is, Nikki, Antonio, anybody else, and they'll be more than happy to guide you on what we have things, okay? And when the next one is, okay?
Thank you.
Again. Have a
Thanks,
good night.
Jason.
Thank you.
All right, bye.